testament that said that the real property, in this case, that would be part of this problem, was treated as part of the assets of that estate. And then at the conclusion of that proceeding, these real properties were transferred over to my client. Mr. Edwards didn't file a claim in that lawsuit, or not in that lawsuit, but in that estate. And it's our position, obviously, as evidence from my brief, is that he was required to do that in order to preserve his claims.
So does that make this factual pattern different because the will provided that real estate would be treated as property of the estate? Is that an important distinction?
I think that it does, to the extent that it would necessitate a claim being made against the estate itself, that the estate had an interest in this real property at one point in time.
But the appellee in this case wouldn't have had a claim against the decedent during her lifetime, right? Because the property had not sold by that point.
Correct. Yes, sir.
Okay.
And so the issue comes, and I think the easiest way for me to say it is, well, why is it that Mr. Edwards couldn't sue Ms. Underwood after the estate is concluded under the theories obviously espoused by him in this lawsuit? And very simply put, it's a matter of Ms. Underwood didn't know, nor did she ever agree to be responsible for these debts by her parents, for lack of a better phrase. And
I'm sorry, you just earlier you said the world was on notice of the affidavits being filed, so your client would have been too.
that's correct, Your Honor.
So we take it that she did know. If the world knows and she's part of the world, then she must have known.
But isn't,
or at least treated as not having known.
Yes, sir, absolutely. And my point is that I think notice and agreeing to be responsible are two different things in the context of these affidavits regarding sales proceeds sharing.
But it seems like to me, to the Chief's point, is that at the point where the administrator of the estate wanted to transfer this real property to your client, Ms. Underwood, she would have said, well, wait a minute, I do not want this property because it's going to come with the obligation of these recorded assignments.
And again, I think it goes back to our position that she's not responsible for those debts at the end of the day.
Well, I would agree with that, and to the point where she said she was willing to accept a deed from the administrator. It seemed like to me that would have been the point where she would have said, well, now wait a minute, I want to disclaim interest in this realty because it comes with these recorded instruments, these affidavit. I mean, why isn't that where she basically acceded to or agreed to accept the burdens of the realty?
Sure, and there's these circumstances that arise, and we all know the phrase buying a lawsuit. Well, we may be on notice of something when we acquire property, and in this case, to the Chief's point, that notice to all the world, these were recorded, we don't dispute that. But the fact of the matter is that people can obviously go forward with a purchase acknowledging that they may have bought a lawsuit, for lack of a better phrase. It doesn't mean that they're going to lose that lawsuit. It doesn't mean in this case that she's actually responsible for these debts. And that's the point that I guess I'm trying to convey at this point, is that we think that because of the nature of these agreements, that they certainly are violative of the statute of frauds whenever you would apply them to Ms. Underwood in her circumstance. She wasn't aware, as she says, of these obligations. She didn't agree to these obligations. And the idea that we can put in contracts heirs and assigns or some similar language that obligates someone in the future to a debt is very different from the scenarios in the case law which opposing counsel has cited as well as the court relied upon.
But again, she had an off-ramp. I mean, she could have very well said, no, do not transfer these properties to me. Let's liquidate them, resolve this issue on the front end rather than just say, well, deed the properties to me and then pretend like, you know, she wasn't aware of the affidavits.
Well, I don't think that we're not saying, we just were ignorant to all this and therefore we're not responsible. That's just a fact, is that she's saying that she wasn't. Now, the notice portion of it is a completely separate thing. What I'm saying, and I hope it's clear, is that she did not assume a legal obligation merely by receiving the properties.
So when she got the properties, or when they were transferred to her, did she record some sort of disclaimer of interest, or?
No, Your Honor,
Okay.
not a thing. It was just she accepted the properties, she went to go try to sell them in the future, and I can't remember if it was the first transaction or the second one where it came up that, oh, there's these affidavits that are out there, we need to do something about this. And obviously not in the record, but it's the issue we discussed about
I
insurance.
mean, I know you're saying these aren't like deeds of trust, but if this had been a deed of trust and the property was transferred, she couldn't have very well have said, well, yeah, I want the property, but you can forget about the deed of trust. I didn't sign that. You know,
Yeah.
that property would come encumbered with the deed of trust. I mean, it just strikes me the affidavits are very similar to that.
And, you know, Your Honor, the issue with them being similar to that may be very true, but I don't think they have the same legal effect, because the deed of trust certainly is something where an owner in the property reserves rights or transfers rights, and someone else has a claim vis-a-vis that document. In this case, these affidavits are merely saying we're going to pay this amount, which is not something that Ms. Underwood agreed to. I'm up on my time, I believe, at this point.
You have your time for rebuttal.
Thank you.
Thank you. We'll hear from the appellee.
Thank you and good morning. It's a pleasure to be here. Pleasure to be here on behalf of Mr. Edwards. During his lifetime, Joe Edwards was pretty close friends with Betty McGrady and also her husband Courtney. And also during his working career, Mr. Edwards was an engineer, surveyor, contractor, essentially a land developer. Those facts kind of collided at the point where the McGradys asked Mr. Edwards for his help and assistance with some farm property that I believe Betty McGrady had inherited. And that culminated into the Sterling Point development that ultimately was very profitable for the McGradys and now for Ms. Underwood. The issues that Mr. Brown has raised, I'm going to try to stay in the same order, but in my mind, the biggest question before the trial court, and perhaps today, was whether or not this was a quote-unquote claim from the standpoint of TCA 30-2-310, and therefore derivatively, whether or not a claim with Mr. Edwards as a claimant had to be filed in the estate of Betty McGrady. Some questions that have already been raised by the court kind of hone in on the main and critical point there, and that is the first sale at issue occurred in 2014. The second occurred in 2015, and the third at issue in 2019. So nearly 2 years had passed after the probate of the estate of Betty McGrady was initiated, and the same time passed before there could have been any possible claim by...
But our probate statute seems to be set up in a way to handle unmatured claims, right? I mean, the actual statute dealing with the notice that goes out says, you know, all parties, all people interested, claims both mature and unmatured.
Yes, sir,
I
I
mean,
agree.
isn't this an unmatured claim? Isn't that exactly what we've got here?
Well, yes and no. This is a statute that I think gives a lot
Well, it
of...
seems like to me if the answer is only partially yes, then a claim
Well,
needed to be filed.
There's very few exceptions that I know of to the strict construction of this statute. But this is one of them because the case law interpreting this type of situation says you basically have to be able to reduce it to a money judgment. And until these properties were sold, there would have been no method, no manner by which to calculate sales price, net sales proceeds.
Well, doesn't 32-317 provide a method? It talks about the order in which an administrator is to address claims, and it has specific provision to deal with unmatured claims. And it says the personal representative needs to hold aside funds until the point where the claims become matured. So why is it that further indication the claim should have been filed against the estate here?
Well, Your Honor, I'm never afraid to say I don't know. I'm not as familiar with the statute that you referenced. But I think it's important to know that the law also states that real estate vests immediately upon death in the hands of a beneficiary. Now, in this case, probate estate was handled in Bradley County, and therefore deeds were signed conveying the property to Miss Underwood, but still, regardless, the law applies, saying when Betty McGrady died, Miss Underwood, as the ultimate beneficiary, intended beneficiary, took the property by vesting at the moment of death, and that also comes with whatever obligations encumber or bear upon the property. And I'm not exactly answering your question, but I'm trying to get back to it. The Chancellor Bryant considered this, and I know of no way that there could have been a claim. And the problem I have, the concern I have with the issue, or the argument is this: if Mr. Edwards had filed a claim against the estate of Betty McGrady, I have to say it would have been denied for the same reasons. And then that gives rise to the issues potentially of res judicata or estoppel at the point in time in the future when the estate, when the property sells, and he tries to make a claim for his fee proceeds, and somebody says, well, you already tried to do that in the probate court, filed your claim, and it was denied, so no money for you either.
Counsel, let me
Yes, sir.
try to simplify it for me here. Let's say your client had a note for $80,000. It was owed, note from the now deceased couple, his friends. Note for $80,000 because it wasn't due for another 2 years after their death. Would he have had to file a claim in probate?
I think he would have.
But it wasn't due.
Well, the note itself would specify the amount borrowed, the interest rates, the balloon payment, terms of repayment, et cetera. And that, in my mind, sir, would be more akin to the majority of the issues we see under the statute, which basically say vested, unvested, matured, unmatured, anything and everything. So I think there's a little bit of a distinction in this case. The other question is, what if the property never sold? What if it still was unsold? There'd be no claim for him to make at this point in time. There'd be no lawsuit to have been filed.
Excuse me for interrupting,
Yes, sir.
counsel. If a claim had been filed, why would it have been denied?
Well, as I understand it, Your Honor, let me refer to page 15 of my responsive brief. What I'm looking for is the language in the case law which states that the word claim contemplates something that can be reduced to a monetary figure, a judgment in a monetary amount. And so in my mind, sir, that's the answer to the question. And also the statute doesn't bar claims of creditors who could be brought against other parties in the form of other legal remedies.
Well, but to Judge Frierson's point, I mean, it seems like anything can be reduced to some sort of valuation. I mean, there's a whole network of appraisers that would be willing to say this property has a market value of X, and a sale would at 6% would result in your client getting Y in my estimation, and then you get a real estate expert that says, and I think this property, if marketed properly, could have sold within 1 year, and then you present value that 1 year number, and that you come up with a number. I mean, it's not perfect, but it is a number.
That's true. And then that would give rise to the question of what would occur if the sale price and ultimately the proceeds to be paid to Mr. Edwards were higher or even less. Just in actuality, it's got to be a situation in my mind where until a sale occurs, in this case, the 3 sales, Mr. Edwards really had nothing that he could have done in pursuit, I don't believe.
I think don't we as a matter of policy want to encourage all claimants to come forward and let the personal representative know about potential claims out there? I mean, you're suggesting a regime where there's these exceptions, and yes, we may know all the universe of claims, but we may not, because we've got a special kind of unmatured claim that doesn't have to be filed, we don't have to resolve before the closing estate, and could crop up at any time of the future.
I have to agree with that in part because that's exactly what the statute, annotations to the statute dictated, is that there's a reason for this. We're trying to smoke out creditors so estates can be opened, closed with finality, and not go into perpetuity with those out there holding their hands open later. But if you step back and look at it again, what was the claim to have been made against the estate of Betty McGrady? The claim ultimately was going to be only available to be made at the time the property was sold, in this case 2 years later, and ultimately the claim was always going to, upon Betty's death, Mr. Edwards only had a choice to pursue his monies and his funds whenever the tracts and properties were sold, and I'm not sure it matters to the extent that he knew that Miss Underwood was going to be the ultimate intended beneficiary. I think that's probably a fair guess because I think she's the only beneficiary as a child. But still, knowing that she would take the property, that gives rise to, or relates to the case law in my mind that says if a person does not need to make a claim where there are other methods and causes of action in the form of legal remedy against different people. So the estate itself, the estate of Betty McGrady, doesn't have to be the focus of the inquiry here, I don't believe, because of the fact that the property vested in Miss Underwood at the time of her death and ultimately remained in her hands until the individual sales.
Well, except in this case, it didn't vest in her really until the deed, correct, from the personal representative, Miss Underwood, and would that be the
Yes, sir.
triggering
That's
event?
always been kind of a confusing issue. I mean, it's vested as a matter of law, but she couldn't do anything with it. She couldn't encumber it. She couldn't sell it until she had a deed.
Counsel,
Yes, sir.
the trial court found that the affidavits created a statutory lien. Is that correct?
Well, I think there's maybe a semantics issue here. The order does say, Your Honor, I believe on the first page, I'm sorry, be the second page of the court's February 27th order that states that the plaintiff is secured and protected by a statutory lien.
All right, so is that the first question that we have to answer, with whether or not the trial court was correct that this created a statutory lien?
If we're looking at the order as written and it says is secured, I think the answer would be yes. But on the other hand, if you read the order in toto, that's not a basis for the chancellor's award of relief.
Well, I'm not saying it's the only question, but
Yes, sir.
you agree that the trial court did say there was a statutory lien. You just read the language.
Yes, sir. She did say that. My interpretation, though, is that, and I think I pointed this out in my brief, at the time that this issue was raised, it was in the form of our response to motion for summary judgment, and there was an issue about whether Mr. Edwards was acting improperly as a real estate agent or broker seeking to collect a commission. And so I pointed out the law about what he was actually doing in the capacity as engineer, developer, contractor, et cetera, stating that even if you ignore these affidavits, he would have been entitled to protection under the lien statutes. But there's no dispute in my mind about the language of the statute at that time and now, which says it's got to be lodged within a certain number of days, and a suit's got to be filed upon it within a certain number of days, both of which terms would long have passed by the time that this case came before the court. So I can't speak for the chancellor. I think I'm correctly reading the context, but that's one issue that the court will have to address. But again, however, I think it's simply a breach of contract case, unjust enrichment case. Ultimately, the situation is these three tracts yielded, I think, about $1.475 million to Miss Underwood. And I don't think it was disputed at the trial or by Miss Underwood that the status and the state situation layout plan with regard to Sterling Point simply wouldn't have existed had Mr. Edwards not been there to provide his services at the time at a discounted rate, ultimately with the fair expectation that these affidavits would be honored. Mr. Brown, on behalf of his client, also raises a statute of limitations and statute of fraud issue. And I'll just briefly say this. As to the statute of limitations, 6 years is what's stated to be applicable. But there's also a knowledge component. You know, the case law says that it's statute such as the one cited would begin to run no earlier than the time when the plaintiff or claimant knew or should have known. Testimony is cited in my brief about when Mr. Edwards found out and how he found out, excuse me, that any of these sales had occurred. But even ignoring that for a minute, the first sale occurred, I believe, in December 11th or 12th of 2014, and the lawsuit itself was filed just a few days shy of 6 years.
Ms. Underwood, could she have, instead of selling these properties, just decided you know what, I like the income coming from the apartment complex, and I can rent out the property. I don't ever have to sell it. And then your client would be completely out, correct?
I don't see why not. I think she could have. I mean, the affidavits are fairly simplistic, one-page documents, and they do not.
Only triggered on a sale.
Yes, sir, that'd be my understanding.
What if she, I mean, so there was a transfer before these sales, that one from the personal representative to Ms. Underwood. That was a transfer for no consideration. Why wouldn't that be a value to base the transfer or your client's compensation on?
You mean the value of zero, or?
Yes.
Or the intended fair cap? Well, I just think in a situation where it's not an arm's length transaction, meaning strangers willing and able buying and seller, that are.
The affidavit certainly doesn't say that. It just
No, it
talks
does
about.
not. No, it does not. It calls for common sense application, I guess. It's sometimes we're looked to rely upon, but I do not see that transfer as a traditional conveyance, because it was in the form of an estate, and essentially as required by administration or probate of the estate. The first sale was when money changed hands. That's the only answer I can give you, Your Honor. I'd be happy to answer any other questions. I've just about used my time, I see.
I hear none, so thank you.
Thank you all.
Hear from the appellant in rebuttal.
Thank you, Your Honor. In this case, at the end of
Let
the
me,
day,
before you get started, of course, 5 lots were sold, right?
I believe that's correct, Your Honor.
And your client paid the 6% on 2 of the lots. And that's the basis for a counterclaim saying, I'd like it back.
Yes, Your Honor.
So she, at least at that point, at least when she paid it, in her mind, she owed the $66,000, whatever it was, on those first 2 lots. Is that correct?
I think there may be some testimony within the record that says that she paid him just so that she could get closed on the lots. It wasn't, again, from a practical standpoint, about insurability of title. If you're staring at a rather large amount of money at that point in time versus arguing about something and not having that money till a later time, maybe the cost-benefit analysis is that I just go ahead and pay it and move on with my life. But I think very limited in the record about that.
All right. So all we know is she did pay it.
That's right.
Now,
Yes, Your Honor.
And then filed a counterclaim saying, I made a mistake, give it back.
No question.
Okay.
The way that, and just candidly with the courts, when I was researching this, I was kind of surprised that I didn't find as much direction as I might have thought there was, particularly in this situation where we have heirs and assigns language that ultimately is what the court hung its hat on to assign responsibility to my client. And so when I was looking at it, I said, okay, let's look at what the court said. We've got this issue with the mechanics and materialman's lien. Respectfully to the court, there's no basis for that to be the reason that this contract is applicable to my client. And I think that is an error that is pretty clear.
Well, but it sounds like the court is analogizing it to an interest in realty. That's the way I would read that. And no one's really you're saying today, but there was no real briefing on, is this type of agreement a interest in realty, or is it a chose in action?
Sure, Your Honor. And I'm just going off of the court's language and its order, obviously. And so I look at that and I say, that's not right. And then I looked at the issue of, do you have to file a claim? I think you do have to file a claim to have that interest against the estate, because it's an unmatured claim. I think the case law, in particular, in re estate of Price, is helpful in that regard. And then we get to this issue of whether or not the heirs and assigns language is sufficient to cause Ms. Underwood to be responsible. The bulk of the case law that's out there, as Your Honors know, is related to these contracts for personal services, and that's really we can't just have those contracts assigned to somebody else because of their nature. Well, this is a debt. So does this mean if credit card companies were to put in language in their credit card agreements that say the heirs and assigns are responsible for these debts incurred by a deceased person, is that going to be something enforceable directly against the heirs and assigns without having to file a claim in an estate? I think that type of scenario and the liberty that can be taken with debts different from such as selling a piece of real estate or personal contracts. I think that's where we get to the problem in this case, where we have a statutory scheme established through the legislator, which says, you know, in claims debt situation, we need you to do.
I mean, the difference between your credit card analogy and the situation here is, though, is your client was able to monetize Mr. Edwards' work for her late mother and stepfather, and change it into cash. So, you know, it would be as if in the credit card analogy, the error sign then started using the credit card. Well, yes, of course, we're expecting them to pay for their charges then. I mean, that seems like to be a more apt analogy here, doesn't it?
Well, I think no matter how you look at it in this context, because there isn't a lien, at least I'm arguing there's not a lien, that it's a debt. This is a breach of contract case. It's not a specific performance case. It's styled as unjust enrichment as well. And I think that distinguishes it, particularly the lack of a lien, from other cases and a suggestion about the credit card, like you say. This is a debt. The language of these affidavits creates this contractual obligation to pay X amount, a debt. And that's what the court, Mr. Edwards is asking Ms. Underwood to pay, a debt. And so I think that's why the credit card analogy with respect, I think it's accurate, because we don't need to look at it outside of what it is, that debt. There's no security. I understand that there was this sale of property which generated the revenue which would have paid it. That's fine. But at the end of the day, it is a debt. And that's the position that I think is the most complicating when it comes to the practical application of this moving forward, is that the statutory scheme exists for probate purposes. Thank you, Your Honors.
Thank you. Of course, thanks to counsel for both sides. We appreciate your arguments this morning and your brief.